Worldwide jurisprudence meant something specific, as the judge noted in the Shostakovich case. It meant that the work itself had to be modified, touched in some way, before the integrity principle could be invoked. The association of a work with discordant political views was not enough in itself to qualify as a violation of the right of integrity. And an interesting footnote to this case, the very same issue was brought before the courts in France, the very same case, and in the French courts, the plaintiffs won. Loss in the United States, a win in France. So you can see that the facts of the case are rather unattractive, but in spite of that, the idea of the right of integrity as a presence in American law did receive a fair and very interesting consideration by the judge. Now I think we need to revisit the ruling in Shostakovich because of a number of changes in the legal framework surrounding the moral rights of authors. In particular, the United States has now joined the Berne Convention for the Protection of Literary and Artistic Works. And of course, this is an event of enormous magnitude in the world of copyright. It signified full-fledged American membership in the international copyright system and a real opportunity for American leadership within that system, which had really never existed before. And the Berne Convention requires that member countries protect the moral rights of its authors. Accordingly, the United States has now become concerned with implementing this commitment in American law. And there are at least three possible methods of doing so, of satisfying that commitment. First one would be a general reform of the US Copyright Act to include moral rights protection. And from a lawyer's point of view, this would be the neatest solution of all, the most straightforward choice. But it's an option that hasn't really been pursued to date in the US, as many of you are no doubt already aware. Rather, it's option two that has had a presence, the possibility of passing special legislation dealing with moral rights. In particular, this has led to the adoption of the Visual Artists' Rights Act as part of US copyright law, an act which, as its name suggests, protects moral rights only in very restricted circumstances for the artists who create works of visual art. Third possibility, of course, is to see the development of the moral rights idea as part of US law through the interpretation of courts, so through the development of case precedent. And this point deserves some attention, because post-Berne, this principle has arisen in the case law on a fairly regular basis. But it has met with only limited success. And the Daystar case from the US Supreme Court, a 2003 case, really seems to set some limits on how far the development of case precedent can proceed within the terms of US membership in the Berne Convention. So what happened in Daystar was an attempt to apply Section 43A of the Lanham Act to a dispute. And the dispute concerned the failure to attribute moral rights to the original creators of a television program about World War II. And in fact, it's quite interesting because there were two potential moral rights claims here. There was a moral right associated with the makers of the original television program, and there was also a moral right associated with the author of the book, which was behind that first program. The author of that book happened to be General Eisenhower, as he then was. The case is interesting from a legal point of view because on the face of it, the Lanham Act doesn't have a lot to do with moral rights. Of course, it's a provision that deals with false advertising. But the analogy between a false designation of origin and a moral right of attribution is quite a striking one. And there was actually an earlier precedent in US law for the success of this particular argument, applying the Lanham Act to a moral rights concern. And that was the Monty Python case, which involved the rebroadcast of Monty Python skits with all of the naughty bits removed. And the Python members felt that that violated their rights of integrity, and they succeeded in pursuing that legally in the United States. But in contrast, the Daystar case failed. And there were two reasons for the failure. The first being the fact that there was a multiplicity of authors who could potentially be treated as points of origin or originators of the work in question. And secondly, the fact that the original work had fallen into the public domain. And of course, by convention under US copyright law, access to the public domain is a very foundation of the law here. Okay, it's supposed to be practically unrestricted. In subsequent interpretation, something interesting has happened as well. The application of this ruling has been enlarged in some significant ways. It has come to apply to works which are still within the copyright term. So it's no longer a ruling about the public domain only, it's also a ruling about works that are still under copyright protection. And it's also presumed to mean that the difficulty of finding a proper origin of a work is effectively insurmountable, thereby invalidating all potential moral rights claims under the Lanham Act. Now, I think that the reasoning of the US Supreme Court in this case raises some questions. The first is fairly straightforward. Is it really proper to treat works in the public domain and works within the term of copyright protection in the same way? The second issue is a little bit more complicated and has to go back to my comments regarding who would be the proper moral rights claimant in this situation. Moral rights theory generally requires that the original author of the work be the claimant, and that original author must be a human person. So a corporation, normally speaking, can almost never make a moral rights claim. This rule does have some exceptions, but they occur in very specific cultural and legal circumstances. For example, Japan actually does have a provision that allows corporations to make a moral rights claim. But I think that that has to be understood in the context of a very different corporate culture from what we know in North America, or Europe for that matter. So here in the Daystar case, we have these, once again, very awkward facts. It's a claim by a corporation for moral rights, and in fact, the corporation that's making the claim is not even the corporation that's responsible for the original work. So very unattractive facts on which to test a moral rights principle in the United States. And I think that the justice's intuition in this case that this is the wrong claimant is probably a correct intuition. But it doesn't necessarily mean that there is no possible rightful claimant, that no one is in a position to be able to make a successful moral rights claim in situations like these. And finally, it's important to keep an eye on the novelty of the claim in question. So again, I think the Supreme Court has the right idea here when it seeks to determine the appropriateness of applying a statutory provision on false advertising to protect the moral right of attribution in a work. But this brings us full circle. What is the alternative under US law? And this really highlights the key difference between the era of the Shostakovich case and the present. When Shostakovich came around, the United States did not have any obligations in relation to moral rights under international copyright law. Now it does. So international obligations are an important reason why the US legal community needs to be interested in moral rights. I will go on to say, it's not just a question of fulfilling international obligations under US law. There's also another question here, which goes back to the title of my book, Moral Rights and New Technology. So there's an issue here about the United States being the leading country in the world when it comes to the digital revolution and digital technology. We have seen the impact of technology on economic copyright through phenomena such as music downloading, film and software piracy, and so on and so forth. But the moral rights issues involved in new technological phenomena have not really been discussed at all, very minimally. In fact, I think what we are going to find is that moral rights are very important in a digital environment for social reasons. So what happens when a work is digitized? Well, we can intervene in that work. In fact, anyone can intervene in it, usually without our knowledge. We can remove things, we can change words, we can insert or remove images, We can change, remove, or add the name of an author. There's so much that we can do to intervene in works. And when these things happen on a fairly large scale, the impact on society could be tremendous. It could cause the corruption of information and knowledge, potentially damage to the integrity of our cultural heritage, the destruction of historical truth. These are likely to become major social issues in a digital environment, even if we haven't yet recognized them or confronted them fully. And moral rights of authors are an important legal instrument for the prevention of some of these problems. Now, given the need for improved recognition of moral rights in the United States, one of the important sources of knowledge available to the US legal community is to consider some of the ways in which moral rights have migrated to different countries and how the doctrine has been received by them. As well, how the doctrine itself is able to adapt to different cultural environments. So I'd like to go on now to consider our international benchmark before we take off on our miniature global odyssey, and consider what the Berne Convention actually tells us about the international baseline requirements in the area of moral rights. Now, the Berne Convention is a classic formulation on moral rights. And when we deal with moral rights in different countries, we don't invoke Berne directly, usually, but it does provide us with guidelines about what legislation on moral rights is supposed to do in the member countries of the Berne Union. And another important point to note, because it wasn't always the case, is that now practically every country in the world is a member of the Berne Convention, the Berne Union. Okay, there was a time when not only the United States, but most of the Eastern Bloc countries were not members. Developing countries had questions about their involvement, and so on and so forth. This period of time in the history of Berne is different. It's a time when Berne has really become very well established in the international community. This is more text than I normally like to put on a PowerPoint, but I'll walk you through it very quickly because there's really no other way to communicate what's in the convention. Masterful piece of drafting as it is. So 4 points to note about the Berne Convention provision on moral rights, which I've underlined. The first, this provision on the independence of authors' economic and moral rights. That's a key provision because what it means is that even after you have physically parted with a work, or after you've parted with the economic copyright in a work, a moral right continues to persist, and you as the creator continue to hold that right. So it creates an interesting legal anomaly between ownership and the control of a moral right. That's what independence means. Secondly, notice that the right of authorship is identified, so there is a right of attribution that is identified by Berne. We also have a right of integrity, a right to protect the work, to object, as they say, to any distortion, mutilation, or other modification of, or other derogatory action in relation to the work. And fourth, notice the clause at the very end of that provision. You can only object to these acts if they would be prejudicial to your honor or reputation. So this is a very important limitation. It means that you as the author bear the burden of proof in a claim for the protection of your moral rights. And it might be difficult to satisfy that particular burden of proof because you need to know what kind of proof you have to offer and how persuasive it's going to be. So, for example, in Canada, the acceptance of expert opinion by the courts is an important principle, firmly ensconced as a result of the one successful litigation on moral rights that we've had in the past 80 years. Economic damage is another factor that is widely accepted in common law countries. I should also mention that this provision may mean that destruction of a work is not a violation of the right of integrity. Although that argument might seem counterintuitive at first glance, the reason is that destruction is said not to affect the reputation of the author. It destroys the work. There is no damaged work there to affect the author's reputation negatively. And I'll come back to that when I talk about the Indian case, because Indian judges are very hostile to that particular view of the right of integrity. They think that destruction should be covered